Hello everyone. This is our second course that I am going to give you remotely. I hope that you are all well and safe at home. I am too. So this is my office at home. It's still a bit weird for me, but let's continue like that. So today our lecture is going to be on counterterrorism and international humanitarian law and IHL. It's a follow-up of last week's course on non-international armed conflicts. Perhaps before we start this course on counterterrorism and IHL, just a small reminder of what we have seen last week. Last week we have seen that the majority of armed conflicts, of contemporary armed conflicts, are non-international armed conflicts. That is, conflicts that oppose states and armed non-state actors. The applicable law to these conflicts is mainly Common Article 3, the Protocol Additional 2, and customary international law. I hope that you have looked at these norms and also read the commentary to Common Article 3, the 2016 commentary, which was issued by the ICRC and that you can find on the website of the ICRC. What we have also seen is that, in fact, if the majority of armed conflicts oppose state armed non-state actors, it makes armed non-state actors the main parties to contemporary armed conflicts. But what are those groups? How can we define them? And here we have seen also that IHL does not give a definition of what is an armed non-state actor. We only know that for IHL to apply, we need to have protracted armed violence between armed non-state actors and the state, or between armed non-state actors themselves. And these actors must also reach a certain level of organization, right? They must be able to launch coordinated attacks. They must be able, for example, to have to speak in one voice during negotiation, or to have headquarters. They cannot be randomly organized because if they are so, and if they don't reach a certain level of organization, then they will not be able to respect the norms of IHL, and it will be another framework which applies to these actors, and in particular, it will be an issue of law enforcement by state authorities against individuals that use force. What we have seen, perhaps, but not in detail, and I should repeat it here, but we will also talk about this a bit later, is that armed non-state actors, members of armed non-state actors, will not be protected by immunity of prosecution if they take up arms. That is to say that it will always be illegal for a group of persons to take arms against a state. So whenever a member of an armed group will be arrested, he or she will be tried by the state authorities for having participated in hostilities illegally. That is not the case for members of armed forces of a state, of official armed forces of a state, of the military, because a person belonging to the military armed forces of a state will be granted immunity of prosecution for participating in hostilities, meaning, or in other words, they will have prisoner of war status. All these rules will apply to armed groups or to member of armed groups, including the rules, the substantial rules on conduct of hostilities, how to respect the civilian populations, the prohibition on the use of certain weapons, but also the fact that they are under the obligation to distinguish between military objectives and civilians, and all the rules that are applicable in non-international armed conflict. Those rules will apply irrespective of the fact that an armed group is considered to be a terrorist organization, or a person belonging to these armed groups being so-called terrorist. You have seen in your reading today of the article written by Ben Saul that there is no actually definition of what is a terrorist armed group under IHL, and there is no definition of what is a terrorist person. What there exists, and this we will see today in the course, is states that actually list some organization as terrorist organization, and those will be treated differently under national law. We will come back to this. So, having this in mind, um, let us now look at what is at stake in this issue of counterterrorism and IHL. This is a slide which quotes the ICRC in a report in 2010, and it summarizes quite well one of the issues related to counterterrorism and IHL. So the ICRC notes that a recent challenge for IHL has been the tendency of states to label as terrorist all acts of warfare against them committed by armed groups, especially in non-international armed conflicts. This has created confusion in differentiating between unlawful acts of war, including such acts committed by domestic insurgents against military targets, and acts of terrorism. So if we deconstruct a bit this quote, we will see first that this issue of counterterrorism and IHL really occurs in the context of non-international armed conflicts and with regard to armed groups. So what states will have a tendency to do is to put all armed groups in the same basket and qualify all armed groups as terrorist armed groups, whether or not they respect IHL. So while it's true that it's difficult in practice to have either a state or an armed group that respect IHL in the conduct of hostilities, generally speaking, there will always be some violation, although they can be graded in a scale of seriousness. There might be cases where an armed group tries to respect IHL by, for example, targeting only military objectives. And this will be an example of how an armed group respects IHL. So it will be lawful under IHL, but states, by categorizing any acts of an armed group as being a terrorist act or being done by a terrorist group, will in fact say in a nutshell that even if it respects IHL, it will be illegal under international law because those are committed by a terrorist armed group. So it will confuse, in fact, the legality of the acts conducted by armed groups. There are other issues that are important when we talk about counterterrorism and IHL. It also blurs it raises issues of the scope of the battlefield. And this is particularly true with regard to targeted killings, for example. So a state will have the tendency to target under IHL a member of an armed group, which will be labeled as a terrorist group. So it will, for the state, it will be legal to target this individual, whether or not it is in a state where IHL applies. We have seen examples, for example, of kidnapping of persons suspected to belong to Al-Qaeda in Italy, and one could wonder whether or not this person was abducted in a way which could qualify as detention under IHL, or that would be a violation of human rights law because in that particular circumstances IHL would not be applicable. There is also a blurring with regard to the use of force against so-called terrorist groups, and it blurs the distinction between jus ad bellum, so the legitimate resort to armed force against an attack committed by a so-called terrorist group. Here, a clear example would be the reaction of some states when the Islamic State conducted attacks in France and in Belgium. Those states resorted to armed force, claiming that it was a legitimate self-defense, but also that they were ipso facto in a state of war against these non-state actors. So there is a blurring between jus ad bellum, jus in bello, and self-defense principles. There is also a blurring of the principles of conduct of hostilities and law enforcement. We are going to go into more detail about the law applicable in conduct of hostilities in our next course. But in a nutshell, it means that here again, so similarly to the issue surrounding the scope of the battlefield, we don't exactly know whether a person, when this person is targeted, whether it's IHL or human rights law that apply. But states, by categorizing all members of armed groups as terrorists or all groups as terrorist organization, will have a tendency to blur the two legal frameworks and apply a bit of IHL and a bit of human rights law. And this we have seen, for example, in Guantanamo with regard to detention, but we have also seen this issue with regard to targeted killings of certain members of the Taliban, for example, in different countries where IHL was not necessarily applicable. We will also go much more into the detail of the issue of targeted killings when we talk about the use of weapons and drones in armed conflict. From a policy point of view, and this is also important because in this class I also want to address the policy level of all these questions. And here we have seen regularly, for example, in the context of resolutions negotiated at the Human Rights Council or at the UN Security Council, that a lot of pressure was put under IHL and human rights in the name of counterterrorism policies. The pressure came, for example, in categorizing certain persons as terrorists, in detention issues, and so you could see, for example, that human rights organizations were negotiating languages in those resolutions, reminding states that when they are addressing or taking counterterrorism legislation, they are obliged also to take into account IHL and human rights and refugee law when applying those domestic legislation. And we will see what kind of domestic legislation I'm talking about a bit later on in this course. We have also seen, but this is perhaps not so much relevant today, but during the post 9/11 context and in the Guantanamo context, there was the tendency to create, the US created from at a policy level, of course, separate category of combatants, and call them illegal combatants. But one must understand that under IHL, there are only two categories of combatants. There are either the privileged combatants, those who have a prisoner of war status, meaning, as I said in the beginning of the course, that these persons will not be tried for having participated in hostilities. They might be tried, though, for having committed war crimes, right? But the mere fact of participating in an armed conflict will not subject them to criminal prosecution. On the other hand, you have civilians that directly participate in hostilities, and usually those are the members of armed groups in non-international armed conflicts are considered to be civilians that directly participate in hostilities. We are going to look into this notion a bit later in the course as well. And these civilians do not have prisoner of war status, meaning because there is no prisoner of war status in non-international conflict, meaning that these persons will be tried by their state if they are detained, and they will be tried for having participated in hostilities because, as we saw in our first courses, only state have the right to use force, has the legitimate right to use force within its border for very for reasons which are regulated in the law. Now, I chose this picture to illustrate, at least to my mind, the blurring of all these different issues, and in particular, the blurring between human rights, law enforcement, and IHL. And not really IHL, but rather counterterrorism issue. So, this is a picture of that shows to what kind of weapons the anti-terrorist police in the UK has. And when I saw this picture once, I thought, well, this is really, I mean, for me, this is not a clear example of a police force. It's rather, it shows rather for me a picture of a military force in the context of an armed conflict. And the type of weapons that are used are heavy weapons that might be used normally in a conflict, in a context of armed conflict. So, visually speaking, also, you can see that there is visually, but also that translate into the action taken by this anti-terrorist police, because one could wonder whether this police will act under the human rights law framework, the law enforcement framework, as it should be, which is more strict and more stringent when it deals with the right to life, and this we have seen in our course between on the relationship between human rights law and IHL, or if this police force will actually feel that it needs to use force in a way which would be more compatible in an armed conflict situation, where the principles of distinction, proportionality, and precaution are different than the ones that are used, and the principles that applies in law enforcement context. Another example I would like you to perhaps look into more in detail, or when you have time at home, is relates to the attack in Westgate in Kenya, in the Westgate Mall in Kenya, which took place on September 2013. And here you had Al-Shabaab the members of Al-Shabaab armed group, the Somali armed group, which conducted an attack in this mall, and their reaction was also quite robust from the police, the Kenyan police. There were some persons who died. But the question at that time was whether or not we were in a situation of armed conflict or not. And I would tend, in Kenya, in this particular situation, and I would tend to say that we would have to go back to this to look more into the facts at that time, whether or not we were in a situation of armed conflict. And so, to illustrate the confusion, perhaps one could look at this statement by the prosecutor of the ICC, Fatou Bensouda, who at that time expressed her deep sympathy to the victims of the appalling attack on the Westgate Mall in Nairobi. And she says such attacks by armed groups upon innocent civilians are contrary to international law and may constitute a crime under the Rome Statute, to which Kenya is a state party. So one could wonder, by using the terms of armed groups and innocent civilians, if she refers to the fact that there might be an IHL framework applicable in Nairobi at the time, or if it was rather a human rights law framework, because these armed groups can also commit, let's say, crimes against humanity. So here, an example also of this blurring, or at least the uncertainty surrounding the terminology when it comes to, let's say, so-called terrorist attack against civilians. And this could apply, for example, to the attacks committed by the Islamic State in France in November 2015, which could be also we could also wonder if at that time, and it was clear at that time that IHL was not applicable in France, but the response taken by the French authority could be also analyzed in a different lens in the view of this debate. There are certain numbers of operational issues. They are not strictly legal issues as we have just seen before, but rather more questions that one might ask when you hear a state talking about counterterrorism operations. So first of all, what is a terrorist group? Okay. The fact is that there is no precise definition of what is a terrorist group, and there is no legal definition. And what we can observe is that states will qualify unilaterally a certain number of armed non-state actors, including, non-state actors which do not necessarily commit terrorist acts as terrorist organization. And because states have a tendency to label all armed groups as terrorist armed groups, then it loses its, let's say, acuteness and pertinence. What we can also see is that no national list of what is a terrorist organization is uniform. It means that for one state, this armed group might be a terrorist group. For another state, it might be not at all a terrorist armed group. So that can create a problem when we talk about classification of armed conflict because, for example, and that is clear, some states like Turkey does not consider that there is a non-state, a non-international armed conflict taking place in its territory. It's not the only state considering this, and many states are arguing that way, is that it's not an armed conflict, but it's counterterrorism. It's a counterterrorism operation. So by saying it's a counterterrorism operation, it diverts the applicability of IHL to the action taken not only by the state, but also by the armed non-state actor. And we will see also that can impact issues of trial of members pertaining to terrorist organization. Then this creates a pressure on humanitarian engagement. We have seen last week how the international community thought it was important to engage armed groups for a better respect of IHL and to enhance the protection of the civilian population that might be in the hands of those armed groups. But by categorizing an armed non-state actors as a terrorist organization, it will prevent humanitarian engagement. And this we will go into more detail in a few slides. And we can also wonder if in this context it will be possible to enhance the capacity of certain armed groups, for example, to conduct, to enhance, let's imagine a very basic way, but the provision of their medical care in a certain area under their control, to provide for doctors or to provide for judges that would help an armed group to conduct a trial in accordance with IHL. And here international organizations will find themselves in the difficulty that providing for capacity support, even for training, to these armed groups might fall under national counterterrorism legislation. We will see this in a moment. So among the examples of national legislation, one can cite the different U.S. statutes that prohibit material support to terrorism. And it declares that it is an offense, so it's a criminal offense, to provide material support or resources to designated terrorist organizations or for the purpose of committing terrorism offenses. The two sections use a common definition for the term material support or resources, which is any service or tangible or intangible property. This can encompass training, logistical support, or expert advice. Violations of either section are punishable by imprisonment of up to 15 years. So here you see an example of a piece of national legislation which clearly prohibits the provision of material support to an armed organization which is designated by the US as a terrorist organization, and it's criminally liable. You can also see that the definition of what is material support or resources is quite large because it encompasses training, logistical support, or expert advice. So one could wonder, what is expert advice? What is training? So one could think, okay, in a certain in this context, it could be military training or military expert advice. Well, that proved to be not the case, and that the interpretation of these clauses were much larger. The Holder case in the US that was decided at the US Supreme Court in June 2010 really set let's say the large definition of what is material support. So the case here concerned a US NGO which was called the Humanitarian Law Project, which wanted to train members of the PKK on how to use humanitarian and international law to peacefully resolve disputes. And this NGO also wanted to teach PKK members, so which is the armed group active in Turkey, how to petition various representative bodies such as the United Nations for relief. So, was that to be considered as material support prohibited by the US national legislation on counterterrorism? And then, if it would be prohibited, it could fall under this legislation and lead to criminal sanction. Well, in June 2010, the Supreme Court held that the forms of material support in the challenge before it were not unconstitutionally vague. Chief Justice Roberts declared that material support meant to promote peaceable, lawful conduct that can be diverted to advance terrorism in multiple ways. A foreign terrorist organization introduced to the structures of the international legal system might use information to threaten, manipulate, and disrupt. This possibility is real, not remote. So what Chief Justice Roberts says here is that by providing training, IHL training, and training on IHL, but international law on how to resolve peacefully disputes and how to seize the UN to claim or to receive relief could be diverted by this organization and could be used for terrorist action in a way. And that, in that sense, this training can be interpreted as being a material support to a terrorist organization and could fall under criminal sanction. When the Holder case was issued, of course, all humanitarian organizations became very nervous and wondered if, when they engage armed groups, we have talked about organizations such as Geneva Call, but the ICRC also engage armed groups. You have members of different NGOs which are actively talking to armed groups for peace mediation. Do these persons could these persons be fall under this particular legislation? So that was a real worry, and a lot of workshop arose, and a lot of discussion. Um, there were no known case where a humanitarian organization was arrested in the U.S. for having provided, IHL training or engage armed groups that are listed as terrorist organization by the U.S. And fall and be arrested in the U.S. and fall under this legislation. So it did not happen in the fact to an international humanitarian organization, but one can argue that this had a chilling effect on the work of certain international organizations when they engage armed non-state actors. Does this piece of legislation also exist, or this kind of legislation does also exist in Switzerland? Well, in Switzerland, you have indeed the Federal Act on the Proscription of the groups Al Qaeda and Islamic State and associated organizations of 2014, which was updated in 2019. It was not updated, actually, sorry, but it's the I gave you the latest status of this piece of legislation. Well, here you can see that there are two groups which are listed as prohibited organization: Al Qaeda and the Islamic State, and also all the members that correspond in their leadership, aims, and methods to Al Qaeda or the Islamic State, or which act on their behalf. So, all the affiliated groups to Al Qaeda and the Islamic State are proscribed under this legislation. And Article 2 says that any person who on Swiss territory participates in a group or organization proscribed under Article 1, supports such a group in human resources or material terms, organizes propaganda campaigns for the term or for their aims, recruits for them, or promotes their activities in any other way, shall be liable to a custodial sentence not exceeding 5 years or to a monetary penalty. So it means, in fact, that here it's a prescription of what is material support to those two organizations that are proscribed under Swiss law. So you'll find that type of legislation in many states, and which, in a way, is indeed a prohibition to also provide some kind of material aid to a designated organization. There was some debate at the time where this legislation was adopted whether the humanitarian engagement to either Al Qaeda or the Islamic State will fall under the legislation. And in fact, there was no exception to the legislation which was introduced. And the discussion was to say, oh no, but humanitarian organizations are not the one concerned by this legislation. You could look into the debate of the parliament at the time, which discussed these issues. But this is what many humanitarian organizations are calling now is an exception to for the benefit of humanitarian organizations when they engage or work with armed non-state actors that might or might not be listed as terrorist organizations, for them to continue their work, their humanitarian work. And so you'll see in the policy context many organizations that are calling for such a humanitarian exception to national counter-terrorism legislation. The difficulties to surrounding the engagement of armed groups has not only been voiced by humanitarian organizations, but by the European Union itself. because European Union not only invests in many humanitarian projects, but also wants to be involved in mediation, in dialogue with armed non-state actors. And here, an interesting quote by the EU, which notes that since 9/11 there has been an increased propensity to refer to or categorize armed groups as terrorist organizations, and governments challenged by non-state armed groups have made ample use of this term with the aim of discrediting the political claims behind those with whom they are in armed conflict and to legitimize zero-tolerance reactions. Associating armed groups to terrorism has a direct impact on the EU and the international community's capacity for mediation and dialogue in transitional processes. If terrorism is a crime, then collaboration with terrorists will also be considered a crime, and this would impede the chances of offering constructive political alternatives to the use of force. The EU needs therefore to look closely at the structural roots and political causes behind the motivation of non-state armed groups, as most insurgency movements cannot be defeated by force and therefore have to be considered as key stakeholders in any negotiations or state building process. I found this quote to be very, very interesting because it says in a nutshell that if we want to negotiate with armed non-state armed groups, because in generally you cannot defeat armed groups just by force. We can see today that armed conflicts are protracted. It means that there is an impossibility to resolve the conflicts by mere force. So at some point you will need to negotiate with these actors, and if states qualify all these actors as terrorist armed groups, well, there will be a structural difficulty, there will be a political difficulty in engaging with terrorist groups only, just, for example, to establish peace. And we don't even talk about allowing for humanitarian access or to allow for other kind of humanitarian engagement. So this tendency to label all armed groups as terrorist armed groups has a chilling effect on many organizations and many international organizations, even when states themselves are involved, such as the European Union. In conclusion of this course, I would like you to watch a debate that we held at the Geneva Academy of IHL and Human Rights on exactly this issue, the impact of counterterrorism laws and policies on IHL and humanitarian action, where you had a panel of different experts discussing this issue. You'll find many also conferences on that theme, but that I thought was interesting because it was the Swiss ambassador to the United Nations, that Ambassador Zellweger, who introduced the debate, and I thought it would be a nice way also for you to be acquainted with this issue. So with this, I finished the course, and again, I am at your disposal if you have any questions. Either you can ask your questions by email, but I prefer that we take an appointment and then we discuss by Skype, for example, after the course, or at some point during next week, if you have specific question about the course of today. So you have to keep in mind that this course is a follow-up of last week's course on the law of Nyack. I encourage you also to do all the readings that are in your reading list, because this will really help you to understand this big contemporary debate. It's really one of the main issues that humanitarian organizations are discussing today, and it's a challenge for IHL as well. So with that, I bid you goodbye, and so stay tuned for our next course. Bye.